All right, gang, it's 12 o'clock, so it's time to begin our webinar for today. Thanks for joining us. And boy, have we got a lot to talk about. The topic today is HIPAA and data privacy. We are going to go through some of this stuff really fast. For those of you who haven't looked at the slides, I think I've got about 110 slides, and I'm not going to be able to cover everything in great detail, but I decided to go ahead and send you the slides anyway so that you've got them for a resource. If for some reason you did not, or you should have received a copy of those slides or a link for those slides, if you did not receive those and would like to receive those, just email Charles at the email that I put in the chat feature. Also, we're not going to be taking questions during the presentations because we're recording it and we want to make sure that it's not interrupted. But if you do have questions, you can go ahead and submit those using the chat feature, or you can email me directly and I'll respond offline. All right, with that said, we're talking about patient privacy, and obviously that entails HIPAA. A couple of comments about HIPAA. A lot of you are aware of the civil penalties. Just remember that HIPAA also has substantial criminal penalties associated with violations of anywhere from $50,000 up to $250,000 fine, from 1 year to 10 years in prison. So if you may have employees who say, well, HIPAA doesn't apply to me directly, you can remind them, oh, yes, it does. HIPAA criminal penalties apply to you. It could apply to other entities who access information improperly or want to access information improperly. So reminding them of those criminal penalties can sometimes help ensure that they comply and cooperate with you when it comes to privacy issues. But for most of you, you are healthcare providers or business associates, so you are primarily interested in the HIPAA civil penalties. Those are updated on a periodic basis. At least last time I checked a couple of weeks ago, the current penalties can range from anywhere from $127 up to about $64,000 per violation. And by the way, each person whose information is improperly accessed or disclosed, that's a separate violation. Or if you fail to implement one of the required standards, each day that you fail to do that could be a separate violation. So those penalties can add up quickly. The key thing to know about the HIPAA civil penalties is it's a structure depending upon, the degree of your conduct, your intent. The good news is if you don't act with willful neglect, you can avoid the HIPAA penalties so long as you correct the situation within 30 days. On the other hand, if you act with willful neglect, then it's a mandatory fine. If you correct it within 30 days, the mandatory fine is about $13,000 up to $64,000 per violation. But if you act with willful neglect and you fail to correct it within the 30 days because you don't like HIPAA or the horse it right in on, then the penalty can be up to $64,000 to about $2 million per type of violation per year. So you want to make sure that you are appropriately address these issues. The other good news is, even though HIPAA has been around since 2003, there really aren't, comparatively speaking, a ton of cases out there. The government usually tries to work with you. They're probably overwhelmed with the number of complaints they may receive. So unless it's fairly bad conduct, then chances are you're going to get a chance to correct the situation. But if it is bad conduct, the government will come in there and look at come after you for it. Here's a summary of some of the recent settlements over the past year or so. I wanted to bring this up for a couple of reasons. If you look at the types of conduct that's resulting in the penalties, it's pretty clear that the most important one are cyber attacks. It used to be that you would get a pass from the government for cyber attacks, but as of a couple of years ago, the government has started to impose penalties for ransomware. If they come in there and look at ransomware or hacks or things like that, and they conclude that you failed to implement the appropriate security rules, then they may come in and cite you for that. Security rule violations, also the right of access violations. We'll talk about that in just a minute. Now, the key to avoiding those HIPAA civil penalties, if you do certain things, then you can avoid willful neglect and you can avoid those penalties so long as you correct the situation. So my quick checklist for helping you ensure that you comply with HIPAA is do the following. Make sure that you appoint qualified privacy and security officers. Make sure you have the required policies and safeguards in place. And we've got a checklist of the required policies and security rule requirements for that. If you ever want to check against what you're supposed to have under HIPAA, shoot me an email. We'll make sure that we get those checklists out to you. You need to make sure that you've got compliant forms, including the authorization, notice of privacy practices. And by the way, the notice of privacy practices is going to have to be updated to address certain new rules that we'll talk about in just a minute. Make sure that you perform and document a periodic security risk assessment. I cannot emphasize that enough, both for cybersecurity reasons, which is the most important reason. We'll talk more about that in a little bit, but also for your compliance. When you look at the big tags that people have gotten because they've been hit for HIPAA cybersecurity violations, almost always part of the reason is that the entity failed to perform and document an appropriate security risk assessment. You need to make sure you execute your business associate agreements, train your members of your workforce, and document your training. That's really important because the government, in their guidance concerning or the commentary that accompanied the breach notification rule and the penalties rule, noted that if you have a rogue employee who goes out and just discloses HIPAA issues improperly, but they were otherwise, you had your policies and procedures in place, you did appropriate training, and this person just went rogue, then the government said that, hey, that's a violation by that person. It doesn't mean that you acted with willful neglect, and therefore you might be able to avoid penalties in that situation, but you want to make sure that you train and document that training for your personnel. Then if there is a violation, you need to respond immediately to mitigate and correct the violation. And if it's required under the breach notification requirements, make sure that you timely report that breach. Generally, if there's any question about whether or not you should report the breach, you should err on the side of reporting it, because chances are if you report it, it'll be like the leaders of the Lost Ark, the final scene. The report will go into the OCR's files and never to be seen again. On the other hand, if you fail to report, then that can constitute willful neglect, and it's a mandatory penalty if the government should learn of that. So the bottom line, if you do these things, then there's a good chance you can avoid willful neglect and you can avoid penalties so long as you correct the situation in 30 days. But of course, that's just talking about the HIPAA penalties that can be imposed by the OCR. There are other costs that could come down upon your head, even if the OCR does not impose penalties. First and foremost, of course, you've got to self-report your breaches of unsecured protected health information to affected individuals, to HHS, and to media if the breach involves more than 500 persons in a particular state. The cost of that investigation and those notices, both in dollars and also in adverse publicity, that can be extensive. So you want to make sure you comply with HIPAA just to avoid that. In addition, in the future, individuals may recover a portion of those penalties or the settlement amounts. The government has issued its request for information so that it can implement rules consistent with the high-tech standards that would require the government to give patients or others whose information is adversely improperly disclosed, that they may be able to recover a portion of those settlements or penalties. That, of course, turns them into bounty hunters and increases the stakes. So we don't have the final rule on that yet, but just watch. That may be coming out before too awfully long. In addition to the OCR, the state attorney general can bring a lawsuit against you. Even if your employees are not worried about the government coming after them, you as an employer, you have an obligation to sanction members of your workforce who violate HIPAA. If you fail to do so, then that's a HIPAA violation on you. And by the way, in October of 2023, HHS issued a bulletin that provided guidance concerning sanctioning workforce members. I'll talk briefly about that a bit later. And if nothing else, you've got to be concerned about possible lawsuits by affected individuals or others for HIPAA violations. Now, there is no private cause of action under HIPAA, but that does not mean that creative plaintiffs' lawyers cannot use HIPAA as essentially the standard of care or use it as a basis for asserting claims under state law. All right, let's talk just about a couple of those issues. Under that HIPAA privacy rule, right of access, as you may remember, the government's been on that. That's been an emphasis they've got an emphasis for them for the last couple of years. They just settled the 48th case under the OCR's right of access. So just make sure that you're paying attention to when you get requests from the patient or their personal representative to access that information. Generally, they're required to access the information in the designated record set. You've generally got 30 days to respond. You can give an extension up to 60 days. Note under the proposed changes to the HIPAA privacy rule, those haven't been finalized yet, but that would cut back that time from 30 days to 15 days. Also under the information blocking rule, you may actually have to provide that response in a shorter time than HIPAA. They actually issued, ONC actually issued a specific FAQ that said that you got to comply with the information blocking rule. You couldn't necessarily just rely on the 30-day HIPAA rule. If you haven't read it already, you should go to the OCR's guidance on the right of access. It's a really important document out there. I know I harp on that quite a bit, but it's required reading for any HIPAA professional. So you can access that at the link. All right, next issue. Let's talk about HIPAA and the online tracking concerns. The new HIPAA rule actually, or the guidance, came out of a couple of kind of high profile situations. There was a hospital that got hit up with a lawsuit and ended up settling for $18.4 million because they allegedly were sharing protected health information through cookies and other web tracking devices. There was an article that came out where purportedly a bunch of hospitals were caught disclosing protected health information through web tracking technologies and the like. The result of that is in 2022, the OCR issued a bulletin warning providers about this. The FTC got involved, and in July 2023, the FTC and the OCR sent letters to hospitals warning them of these. They got sued. The OCR got sued by the American Hospital Association and the Texas Hospital Association, claiming that they were going too far in this guidance. So in March of 2024, the OCR issued its updated guidance, which changed a little bit, but not a whole lot, the prior guidance that issued. Under the current guidance, you can go ahead and access that on the government's website. Importantly, though, if you maintain a website or contracting with business associates to help you with your website, navigation and the like, there's a good chance you need to be concerned about this direction from the government. It applies to online tracking technologies. What are those? Well, I'd have to defer to my technologically more proficient people than I to understand exactly what they all are, but there are things like cookies, web beacons, tracking pixels, and the like. It also, they express concerns about mobile apps, because mobile apps can also track protected health information or at least individually identifiable information. So assuming these tracking tools are accessing individually identifiable health information concerning a person's healthcare or payment for their healthcare, then HIPAA is going to be triggered. And the question is, okay, well, why are they using that information? Because HIPAA would only allow you to use that information for certain purposes without the patient's authorization. In that guidance, the government emphasized the regulated entities. Those are entities that are covered by HIPAA, i.e. covered entities and business associates. They're not permitted to use those tracking technologies in a manner that would result in impermissible disclosures of PHI to tracking technology vendors or any other violations of the HIPAA rules. So to analyze kind of how this works, you have to step back and look at, okay, what's the purpose? Why are you using that data? You've got these tracking technologies that are collecting the data. To determine whether or not there's a potential issue, you have to ask yourself these questions. Well, is that data coming from or through a covered entity or a business associate of a covered entity? If it is, then potentially HIPAA is going to apply. If it's not, if it's being collected by some other health app that's not from a covered entity, then HIPAA's not going to apply. There may be other issues that we'll talk about in a little bit, but not HIPAA. The next question, is it protected health information? Are those tracking technologies collecting protected health information? To be protected health information, it has to be individually identifiable. But remember, that's a very broad term. And under the de-identification standards, we know it includes things like names, addresses, phone numbers, emails and IP addresses, URLs, device identifiers, or any other unique identifying number, characteristic, or code, MRI numbers, account numbers, things like that. That's all individually identifiable health information. And presumably a lot of those tracking technologies are picking that stuff up. So then the question is, does it relate to a person's past, present, or current healthcare, or payment? You got to have both of those things. If you've got both of those things, then you've got protected health information. So if you've got protected health information, okay, Well, how are you using or disclosing it? Are you using or disclosing it in a manner that's permitted without the patient's authorization? If it's use or disclosure by the covered entity, well, generally that means is it for use or disclosure for healthcare operations, treatment, payment purposes, those types of things. A lot of you may mistakenly assume that anything you do is healthcare operations, and that's not the case. I'm going to come back and talk about that in just a minute. On the other hand, if it's the business associate who is using or accessing or you're disclosing information to that business associate, they can't just do whatever they want with that data. They can only use that data under HIPAA if it's for a permissible purpose that the covered entity could use it for, right? They can't use it for anything, with a couple of very limited exceptions. They can't use it for any purpose that the covered entity couldn't use it for. So again, their use would have to be for the covered entity's healthcare operations, treatment or payment purposes like that. There is an exception for the business associate's own management and administration purposes, but that's probably very narrow. It's not for any purposes that it wants. We'll talk about that more in just a minute. And next, finally, is it permitted by the business associate agreement? Because the business associate can't use that information it gets on behalf of the covered entity for any purpose unless it's permitted by the business associate agreement. If it doesn't, then if it uses is outside the scope of the business associate agreement, then it's a violation of not only the business associate agreement, but a violation of HIPAA. Next, even if they satisfy that, you should check to see whether or not that use is consistent with your notice of privacy practices or any specific agreements that you may have with the patient. Unless you can satisfy all of those, you're generally going to need the patient's authorization to use or disclose that protected health information. So then the final question is, okay, do we have the patient's authorization to use or disclose that information? Now, quite often, healthcare entities will say, well, we're using this tracking technology for our healthcare operations. But healthcare operations is defined under HIPAA as any of the following activities, but only to the extent those activities are related to a covered function. A covered function is basically what the entity does, a covered entity like a healthcare provider, the things it does to be a healthcare provider. It's not stuff outside of that, like marketing or those types of things. It's the stuff it does to be a healthcare provider. And there's a list of what are healthcare operations in the definition. Note, it is not anything you want to do or anything that's even related to the operation of your organization. It's only these specific things that relate to your capacity, what you do as a healthcare provider, not just operating a business. In fact, in the preamble to the HIPAA final rule where they discuss the definition of healthcare operations, they specifically said that there's certain things that are not fundamental to your function as a healthcare provider, and therefore they would generally require authorization. They don't fit within the definition of healthcare operations, including marketing of health or non-health items or services, disclosure of PHI for sale, rent, or barter, use of PHI by the non-health related division of an entity, or fundraising. For those types of things, at least back when HIPAA came out, they said that's not healthcare operations, and therefore you would need another HIPAA exception or the patient's authorization. All right, so that's covered entities' use of those tracking technologies. What about a business associate? Well, as I mentioned, under HIPAA, the business associate can only use that protected health information it receives or generates on behalf of the covered entity for certain purposes that are permitted by the business associate agreement. If their use is not permitted by that business associate agreement, if it's not covered by that, and one of the requirements is you got to specify the permissible uses. If it's not permitted by that, then it's outside the scope and they can't use that information. In addition, they can only use that information, protected health information, to the extent the covered entity could use or disclose the protected health information. Now, the limits of that are they can use it for data aggregation services, but that's data aggregation services related to the healthcare operations of the covered entity. And we just learned that healthcare operations is not very defined. And so it has to relate to the healthcare operations, not the business associate's own healthcare operations, but the healthcare operations of the covered entity. It's basically data aggregation services, where the covered entity allows you, the business associate, to go in there and aggregate data from multiple covered entities and then use it in a manner that doesn't disclose that information improperly to its clients who are covered entities. It also allows the business associate to use it for its own proper management and administration, but again, that's probably very narrow. It's not for anything you want to do as a business associate. It has to be for just your management and the administration of your service as a business associate, but not for necessarily for things like R&D or product development or those types of things. HIPAA would allow you to go ahead, if your business associate agreement permits it, to allow your business associate to de-identify data on behalf of the covered entity. That would be a permissible use, but it would have to be covered by the business associate that the covered entity allows or authorizes that business associate to de-identify the information on behalf of the covered entity. Then once de-identified, it's no longer protected by HIPAA. Then in that situation, the business associate could go ahead and use or disclose that information because it's no longer protected health information. The bottom line here is the government specifically says business associates, with very limited exception, cannot use PHI for their own purposes, including data mining. That is not permitted. So those are the permissible uses. Let's go back to the guidance then. In that guidance, they specifically talk about authenticated or unauthenticated web pages. The government, the OCR basically said, hey, if you've got a user authenticated web page where the person has to log in and give, identifiable information before they can access that web page, then there's a good chance that's likely going to involve protected health information, and the HIPAA rules are going to limit your use or disclosure of the information that's gained by those tracking technologies after that point. It's going to have PHI because if you're logging in, then you're going to have identifiable information, and there's a high probability that the information that person's going to input after logging in is going to relate to their past, present, or future healthcare, or payment. Now, it's possible you may have situations where it does not relate to their healthcare, and in which case it would not be PHI, but the assumption is for most of those, it's going to be triggered by PHI. Well, what if it's not a user authenticated web page? What if it's maybe just your main landing page or something like that anybody can go to without having to log in, so it hasn't been authenticated? The government said, well, in those cases, they likely do not implicate PHI because a person logs in is not sufficiently related to the person's health care. On the other hand, they said there may be some situations, however, where it is related. And they gave the example of a person goes on to a hospital's website. Maybe they've got a cancer diagnosis and they're going on to get information about other cardiology providers so that they can get a second opinion. The government said in that situation, that would be PHI. Now, of course, that analysis doesn't make a whole lot of sense because that would require you as a covered provider to basically know the intent for anybody who goes onto your web pages. Why were they there, right? And you have no idea how that's going to occur, because so that standard really is untenable. Probably will be part of, if it's not already, part of the lawsuit that's currently ongoing on this. But just beware of those situations. If you are a healthcare provider and you're providing a mobile app in order to assist your patients, well, then that's probably also going to implicate the tracking technology guidance. On the other hand, if you're not if you're just using a mobile app that's not provided by a covered entity, a healthcare provider, or a business associate on behalf of that covered provider, then it's not going to be covered by HIPAA. For example, I've currently got on my Apple Watch, right? That's measuring my steps and the like. Does it have health information? Yeah. Is it provided by a covered entity or a HIPAA regulated entity? No. So it's not necessarily going to be trigger HIPAA for that type of stuff. But the FTC health breach notification rule may apply. We'll talk about that more in just a minute. And, as a practical matter, I can't imagine the government really going after many hospitals or healthcare providers for violation of these rules, given kind of the ambiguous nature of the guidance and those types of things. But there's a potential. Even if you're not worried about the government coming after you, though, you need to be worried about private enforcement, because remember that case that started it all? And I noted in a recent article in the National Law Review that there's this trends for web tracking class actions. So be aware of making sure that your tracking technologies are compliant with HIPAA. As long as we're talking about, the government identified some of the things that you need to be concerned about when dealing with online tracking. You need to ensure the uses of PHI are collected from the tracking technologies or for permissible purposes, like we talked about, like treatment, payment, or healthcare operations, or you'd have to get the patient's authorization. You need to then ensure the disclosures to the vendors are permitted by the patient agreements and the business associate agreement. You need to make sure you comply with the minimum necessary rule. You need to obtain the HIPAA's compliant authorization if necessary, if it involves PHI and you don't have a permissible purpose. Big note here, just because your web page has privacy notices or terms and conditions, that does not satisfy HIPAA. Those will not satisfy a HIPAA authorization. HIPAA authorization requires certain elements that are not commonly found in those, just your website banner that has your privacy policies. So you need to not rely on that. You need to obtain your business associate agreement with vendors who are helping you with your websites, if they're using any kind of tracking technology, if they're going to receive any protected health information. A lot of those will refuse to sign those business associates. And I don't know what to tell you in those situations. In those situations, you may just have to not contract with them, or maybe agree with them if they will to, as a business associate, so they still have to sign a business associate agreement to de-identify that information on your behalf, and then they can use it at the back end after it's de-identified, but they'd still have to have a business associate agreement with you. In addition, when it comes to those tracking technologies, you need to make sure that you comply with the HIPAA security rule requirements. The OCR emphasized that it's prioritizing compliance with the HIPAA security rule and investigations into the use of online tracking technologies. All right, and as long as we're talking about communication of EPHI, just remember that you got to comply with the, if you're having any communications with your patient or transferring protected health information via electronically, that the general rule under the security rule is that information has to be encrypted. Now that's an addressable standard, so it's not essential as long as you satisfy the standards for an addressable standard, but it's pretty hard to satisfy an alternative to encryption. If you're communicating with patient via emails or texts, remember that the security rule still applies. So generally those have to be communicated via a secure platform that's encrypted, unless you notify the patient and the patient that the platform you're using is not secure and the patient agrees to receive it by secure means. They have the right to have those communications by unsecure means. You just want to make sure that you don't want to document that. All right, the next big one we wanted to talk about was the reproductive rights rule. A little bit of background might help, because in the wake of Dobbs, the federal government, the current administration was concerned about reproductive rights and the impact that Dobbs might have. Particularly, they were concerned about situations where a state, in state A, it prohibits abortions or certain actions on reproductive rights, but its next door neighbor, state B, permits it. And the government was concerned about the officials in state A getting information about patients who may go across the border to state B to get an abortion and the like. And therefore, they came out with the reproductive rule. It was issued in April. It takes effect in just a couple of days, right? And June 25th. But actually, the government has said they're not going to actually enforce it or expect compliance until December of 2024. There are certain requirements under the Notice of Privacy Practices that they're going to give you until February of 2026. We'll talk more about that just briefly. Essentially, this new rule provides certain extra rights for reproductive health, protected health information concerning reproductive health, which is defined as healthcare that affects the health of an individual in all matters relating to the reproductive system and to its functions and processes. Very broad. The rule states that if the reproductive health care is legal where it occurred, then covered entities may not disclose the reproductive health care protected health information for purposes of criminal, civil, or administrative liability or investigation into any of those. In addition, before you can make a disclosure, you've got to obtain an attestation from the person seeking that reproductive health care that they can appropriately access that information. So the scope of this does not necessarily protect all reproductive PHI. It only applies really in kind of a limited situation. So let's talk more about that. So under the rule, a covered entity and business associate may not use or disclose protected health information to anybody for purposes of conducting a criminal, civil, or administrative investigation into any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care. In addition, it can't be used to impose criminal, civil, or administrative liability on any person for the mere act of seeking, obtaining, providing, or facilitating reproductive health care, or identifying any person for the foregoing purposes. So the general rule is that you can't use or disclose protected health information for these purposes, right? For the civil, criminal, or administrative liability. But that rule prohibiting those disclosures only applies, or it doesn't apply, if the situation, it only applies, that prohibition only applies if the healthcare that was provided is legal. So the prohibition on the use or disclosure of reproductive care, PHI, only applies if, meaning that you can't disclose the information if the activity was legal. And that's defined as the activity is in connection with a person seeking, obtaining, providing, or facilitating reproductive health care. That means expressing an interest in, using, performing, furnishing, paying, or disseminating information about, blah, 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 reproductive health care. Okay, so it's pretty broad. So if the activity is being sought, or the information is being sought, and it relates to the person's reproductive health care, and you determine, the covered entity or business associate determines that one of the following exists, then that rule prohibiting disclosure is triggered. Okay, so it has to relate to reproductive health care, which is very broad, and the covered entity or business associate has to determine that one of the following exists. Either the reproductive care is lawful under the state law in circumstances where it was received or sought, or the reproductive health care is protected, required, or authorized by federal law. So if the federal law, maybe EMTALA or something else, authorizes that care, then in that situation, that bar takes effect and you can't disclose that. Now, the care is, the statute contains a presumption so that reproductive health care is presumed to be lawful unless the covered entity or business associate has actual knowledge that the care was not lawful, or the factual info provided by the person requesting the information shows that it was not lawful at the time. So, backing up here, if it's illegal activity, if they're seeking information about reproductive health care that was illegal, then this rule doesn't apply. On the other hand, if they're seeking information about healthcare that was legal, reproductive healthcare that was legal where it was provided, then this rule does apply and it generally prohibits you from making that disclosure. They also indicated there's an exception under HIPAA that allows you to decline to provide information to the personal representative if you think it would result in abuse or neglect. The government just clarified that just because the parent thinks that the reproductive health care was improper does not mean that that's a reasonable belief that for abuse or neglect. All right, so that's the first part of the reproductive rule. The second part is in those situations where somebody comes in and asks for the information, even in those situations, the covered entity has to, or business associate has to request a required attestation, and they can't provide the information without this required attestation. So the covered entity or business associate may not use or disclose reproductive care, protected health information for certain purposes without first obtaining a required attestation from the person seeking the PHI. Those purposes that require the attestation before you can disclose it are if they're seeking it for purposes of health oversight activities, or disclosures for judicial or administrative proceedings, or disclosures for law enforcement purposes, or disclosures to coroners or medical exams. If that's their purpose for getting it, that's the HIPAA exception that would allow them to get the information. Then you've got to get that attestation, and that attestation has to satisfy certain regulatory standards. It's got to contain this specific required information. And significantly, it can't be combined with another document, and it cannot contain additional elements beyond these elements that are required within the regulation. The government has indicated they intend to publish a model attestation form. So if you are involved at all in either providing reproductive health care so that you have these records, or you receive records or maintain records involving reproductive health care, whether you are the provider who actually rendered it or not, then you need to make sure that you're aware of this rule, and you need to make sure that you get a copy of that attestation so that you can build it into your policies. The government actually, sorry about this, guys, but right now the government is actually conducting a webinar on the reproductive rights rule. I thought about postponing this webinar when I found out about this, when they issued this notice a couple of days ago, or a few days ago, but we'd already had a bunch of people sign up. So presumably it will be recorded so you guys can go back and get it. All right, that is a summary of the reproductive rule. Now, they actually had another aspect of this that came out that I thought was interesting. There was kind of a tag along. The government was concerned about situations where you have police officers or investigators who show up and they request that you provide information. They don't come with a warrant. They don't come with a subpoena. They just show up and request the information. And they rely on an exception that would allow you to disclose information on an administrative request. And I've had people come in there and say, prosecutors or others say, well, we gave you an administrative request. The government in the reproductive rule confirmed that no, just because an officer requests the information, that's not what we meant. An administrative request for purposes of this rule requires that your response has to be required by law. So it'd have to be like a civil investigatory demand or something like that. It's not enough for them just to do an investigation, come in there and ask you for a request. They have to there has to be some law that would require you to provide a response. So they clarified that in this new rule. So if you have people showing up, wanting that information and trying to rely on this administrative request, your response should be, well, show me the law that requires me to respond, because now in the wake of this new rule, I can only provide information in response to an administrative request if my response is required by law. All right, a couple of other things going on with HIPAA. In last October, the government emphasized its concerns about complying with HIPAA in the course of telehealth. They actually published a helpful guide for providers who are providing telehealth on how to comply with HIPAA when it comes to telehealth. If you haven't received that and you're providing telehealth, you may want to call that up and take a quick look at that guidance. As I've mentioned a couple of times, the government has proposed an additional, some pretty significant changes to the privacy rule. That proposed rule has been pending since January of 2021, but we're still waiting for it. I think that it'll be coming out before too awfully long. We'll have to see what the final rule actually looks like. The proposed rule, though, did address the individual's right of access. As I mentioned, that's been a big emphasis for the OCR for a few years now. Among other things, the proposal would be that individuals will not only should be allowed access, but they'll be allowed to use their personal devices to view or capture images of PHI. I guess that saves them from having the cost to having to pay the cost to have you copy that stuff and send to them. You've got to respond to requests for access within 15 days instead of 30 days. You must share the information with a third party if you're directed by the patient to send it. Right now, the current rule, as modified by the SIACS case, if a patient comes in and wants you to send electronic information to a third party, then you're obligated to, but not just paper copies. This would broaden that requirement. And there will be additional limits on the amount of money that you can charge for producing protected health information. Again, this is all prospective. It's in the proposed rule. We don't know what the final rule will actually look like. All right, let's talk next about substance use disorder records. So we're switching from HIPAA to the SUD, substance use disorder records. Just remember that when we're talking about privacy laws, there's a bunch of laws that are out there. HIPAA is the big one, right? But for those of you who are federally assisted programs providing SUD care or maintaining SUD records, then you've also got to comply with 42 CFR Part 2. Or if you are a recipient of such SUD records from those Part 2 programs, you got to comply with Part 2. When it comes to compliance, you have to comply with the most restrictive law. In most cases, in a lot of cases, Part 2 is more restrictive than HIPAA, so you're going to have to comply with Part 2 in addition to HIPAA. Proposed rules were issued way back when, in February, but they were issued back in, I think, 2020, as I recall. But the final rule was actually issued in February of 2024. It took effect in April of 2024, the new rules concerning Part 2 SUD information. But the government said that they're not going to actually enforce these new Part 2 rules until 2026. Now, you may want to implement them before 2026 because in a lot of ways, the new rules are going to be helpful to you. But you don't actually have to comply with them if you don't want to until February 2026. The new rules basically implement the prior CARES Act requirements. And the whole intent was to make sure that they align Part 2 more closely with HIPAA. So to that extent, under the new rules, under the old rules, it used to be that you could be criminally liable for violations of Part 2. Under the new rules, they basically said the HIPAA rules apply. So the OCR now enforces Part 2 along with HIPAA. The HIPAA penalty structure for those civil penalties now replace the old Part 2 criminal penalties. If you have a Part 2 violation, then you've got to do the breach notification just like you would under HIPAA. Some other important factors, some other important changes. It now allows Part 2 programs to use a single consent for any uses or disclosures that are for purposes of treatment, payment, or healthcare operations. So that you can have a patient sign a single consent at the outset, and that applies to all further disclosures for treatment, payment, or healthcare operations until the patient withdraws that consent. You don't need a specific consent for each one of those, but it only applies to consent for treatment, payment, or healthcare operations. For other disclosures for other purposes, you would need a separate consent unless you fit within an exception under Part 2. It also allows HIPAA-covered entities and business associates who get SUD information from a Part 2 program under consent from the patient. They may use or disclose those that information further consistent with HIPAA. So as long as they're complying with HIPAA and making further uses or disclosures, they can do that. And finally, under the new rules, you've got to provide, Part 2 providers have to provide a notice of privacy practices that's similar to HIPAA. For other entities, you're going to have to not modify your notice of privacy practices to accommodate these Part 2 programs. That's an overview. I'm going to cover some of this just real briefly, but I did a whole program on the new Part 2 rules a couple of months ago. So if you want more information about the Part 2 rules, you can just go to our website. You can download that, the hour and a half program that was dedicated directly to those Part 2 rules. In general, Part 2 applies to information that identifies a patient as having had or referred for a substance use disorder condition, and it has to be created or received or acquired by a federally assisted program. So the question is whether or not the information was for a federally assisted SUD program. We're going to talk more about what that is in just a minute. Generally, a Part 2 applies if it does involve this SUD information created or generated by a federally assisted SUD program. Then Part 2 prohibits the use or disclosure of that information unless you have the patient consent or you fit within a limited exception under HIPAA. If those Part 2 programs are going to provide Part 2 information to somebody else for a permissible purpose, then you generally have to provide this notice to those other entities. In addition, you have to provide a Part 2 notice to the patient concerning your obligations to comply with Part 2. Now, it only applies to federally assisted programs, or at least that's how it starts out. Now, federally assisted, if you're receiving Medicare, Medicaid, or licensed by the federal government in any way, you're going to be federally assisted. So almost everybody's going to be federally assisted. The real question is whether or not you're a Part 2 program. The way that the Part 2 program works is if you are not a general medical facility, so you're not a hospital or a FQHC or something like that, then the question is, you are a Part 2 program if you hold yourself out as providing substance use disorder, diagnosis, treatment, or referral for treatment, and you actually provide that. So if you're out there in the public saying, hey, come to our clinic, we provide this SUD care, then you're going to be a Part 2 program. On the other hand, if you are associated with a general medical facility like a hospital or an FQHC, maybe a large physician practice, then whether or not that entity is a Part 2 program depends on the following. If you have an identified unit within that general medical facility that holds itself out as providing SUD diagnosis, treatment, or referral and actually provides it, then that medical facility, or actually that unit, is going to be a Part 2 program. Again, it's a question of whether they're holding themselves out as that. Alternatively, even if you don't have an identified unit, if you've got identified medical personnel whose primary function is to provide SUD diagnosis, treatment, or referral, and they're identified as such providers, then in that situation, then those providers could also be a Part 2 program for purposes of this Part 2. It would not apply to just primary care providers who don't hold themselves out as providing SUD care, but just happen to do it periodically, or if emergency physicians who may provide that care just because somebody comes in, but that's not really anything that they're holding themselves out as, then they would not be a Part 2 program. If you are a Part 2 program, though, however, you're going to have to comply with the new rules under Part 2. Those Part 2 rules apply to just the Part 2 program. So if it's a Part 2 program within a hospital or the like, the Part 2 rules apply to the portion of the hospital, that identified unit or those identified providers who provide those services. The rest of the hospital is not a Part 2 program, but before that Part 2 program can share the information with the rest of the people in the hospital, then they would have to satisfy the Part 2 limits or requirements on that. The Part 2 rules not only apply to the Part 2 program, but it also applies to entities who receive SUD information from the Part 2 program or on behalf of the Part 2 program, including entities with direct administrative control over the Part 2 program, a qualified service organization, which is an entity that is retained to provide services for the Part 2 program. It's basically a business associate of the Part 2 program. And like a business associate under HIPAA, the qualified service organizations have to sign an agreement with the Part 2 program called a Qualified Service Organization Agreement. That's basically a business associate agreement whereby they agree to comply with Part 2. It also extends to lawful holders of SUD information. Those are entities or persons who receive a copy of the patient's written consent, allowing disclosure of the information to them, along with a notice advising them that, hey, these are Part 2 records, and guess what? Tag, you're it. Now you've got to comply with Part 2. Or situations where that recipient received the information per an exception to a written consent requirement. Okay, let's talk about some of those situations. So the general rule is, before a Part 2 program can provide SUD information outside its organization or even within the Part 2 program, you got to fit within a HIPAA exception, or you got to fit within an exception, or you've got to have the patient's consent. The situations where that SUD program can provide the information without the patient's consent, they can disclose it within or use it within the Part 2 program to those who have a need to know. They can disclose it to entities that have direct administrative control over the Part 2 program. They can disclose it to a QSO, a Qualified Service Organization, if they have that agreement in place. There's exceptions for report to law enforcement, suspected child abuse, medical emergencies, audits, things like that. So those are some situations where you don't have to have the patient's consent to disclose SUD information. Most of the time, though, you're going to need the patient's consent. If the disclosure is for treatment, payment, or healthcare operations under the new rule, you only have to get one consent. So you could have the patient sign that one consent when they first come in. And that applies to all further uses or disclosures of treatment, as long as that use or disclosure is for purposes of treatment, payment, or healthcare operations. For any other uses or disclosures for other purposes, then you're going to have the patient's consent, and you're going to have, it's got to be specific to that particular use. In order to have an effective consent under Part 2, that consent has to contain certain required elements that I'm not going to go through today, but you're going to want to crack the regulations and make sure your consent forms have those required elements. And when you provide that disclosure per the consent, if you're a Part 2 program or a recipient of that Part 2 program, you've got to provide a copy of the patient's consent, which sets forth the parameters of what you can do, right? And a certain notice. That notice has to advise the people the recipients, that, hey, this is Part 2 information, you got to comply with the law. There's two different forms that you can choose either of these forms. The forms are set out in the regulations. There's either the long form that gives them a bunch of guidance, or you can use the short form. You may actually want to use the long form because that's going to provide more information to the recipient so that they particularly understand what their obligations are. It's helpful to go through that. Under the form, it says, if you are the recipient of this information, the federal rules prohibit you from making or any other use or disclosure of this record unless unless at least one of the following applies. So you got this form, you got these records, and you got this form. This tells you as a recipient what you can do with this information that you've got. You've got to satisfy one of the following before you can further use or disclose that information. Further use or disclosure, you can make it if it's expressly permitted by the written consent of the individual whose information is being disclosed. And remember, as part of this disclosure, you got a copy of the consent plus this notice. You can look at the consent to see whether that consent would allow you to use or disclose the information. Or, this is a significant change, if you are a covered entity or a business associate and have received the record for treatment, payment, or healthcare operations, then HIPAA, under the new rules, if you're covered by HIPAA, a covered entity or business associate, and the use or disclosure for purposes of treatment, payment, or healthcare operations, then you can go ahead and use that information for purposes of treatment, payment, or healthcare operations, so long as it's consistent with HIPAA. All right. Under the Part 2 rules, the patient has certain rights. They basically track the kind of rights that are provided under HIPAA. Among other things, the Part 2 program has to provide a notice to the patient of their rights. It's similar to a notice of privacy practices. If you are a Part 2 program, you're going to want to call up the new rules to make sure that this notice that you're giving it to your patients and that it satisfies the particular requirements. Part 2 requires Part 2 programs to implement certain security rules that are similar to HIPAA. Just remember that if you're a covered entity or a business associate, in addition to being a Part 2 program, you've got to comply with HIPAA as well as the Part 2 program rules. I know I went through that Part 2 stuff pretty fast. I just wanted to give you a heads up concerning that. The government has additional guidance concerning Part 2. They posted a webinar where they talk through the new rules. SAMHSA has a bunch of resources. They're the entity that kind of implements Part 2, so you can go to SAMHSA and get more information about Part 2. On the Office of Civil Rights, remember they're now the new enforcement agency for Part 2 as well as HIPAA, and they've got guidance concerning HIPAA and Part 2. And like I said, you can go to our webpage and you can access a webinar that I did. All right, let's talk about HIPAA Notice of Privacy Practices, because in the wake of the new reproductive rights rule and the Part 2 rules, you are going to have to modify your Notice of Privacy Practices, but you're not going to have to modify it until February 2026. The exception might be if you're a Part 2 program and you want to the greater flexibility, use or disclose the information for treatment, payment, or healthcare operations under the new rules, then you may want to modify it sooner so that you can comply, get the benefit of those new rules, but you would need to make sure that your use is consistent with your Notice of Privacy Practices, so you need to update your Notice of Privacy Practices. The rules are generally the same, but there are some changes that you're going to have to make for the notice. I've highlighted those changes in red in the documents that I provided. Among other things, you've got to make reference to Part 2 and provide some information about Part 2. All of these requirements are specified in the reproductive rights rule. You can go there and track what your Notice of Privacy Practices has to contain. In addition to the other stuff that it currently requires, you've got to provide a description and an example of the uses and disclosures of reproductive protected health information that's prohibited by 45 CFR Part 2. So you advise your clients that, hey, we can't disclose your information for criminal, civil, or administrative liability or investigations. Therefore, if the conduct, the reproductive health care was legal, you've got to provide a description and the example of uses and disclosures for which the attestation is required. You've got to include a statement that information disclosed per HIPAA may be subject to redisclosure by the recipient and no longer protected. That's been a part of your authorization form, but now they've moved it, and you've got to also include in your Notice of Privacy Practices. You've got to notify individuals of if they're an SUD program or you have SUD information, that they've got certain rights concerning that information. The good news is that OCR intends to publish a model Notice of Privacy Practices, so you may want to wait and take a look at that new notice when it comes out and maybe model your Notice of Privacy Practices similar to that. A word of caution, the government has a model Notice of Privacy Practices on their webpage. It's been on there since, I think, right around 2010 or so. but it's not a very good notice. It includes a lot of requirements or suggests that there are a lot of requirements that you really don't have under HIPAA. So you may want to look at any model notice that the government produces just to make sure that you want to go there. All right. And I ought to mention too that in the proposed HIPAA rules, those ones that have been pending since 2021, there are additional changes to the notice of privacy practices. That's really why I think the government is not requiring you to put in place the new notice of privacy practices requirements until February of 2026. It's because I think the government wants to get all of these new notice requirements out there, not only the reproductive rights in the part 2, but also the new notice requirements under the proposed rules before they're actually going to enforce it. So watch for that stuff. As I mentioned earlier, I want to emphasize this because if you're operating a website, you almost always have your website terms and conditions and privacy issues, privacy statements. That was probably developed by your website developer. Just realize that that doesn't satisfy HIPAA. HIPAA, you've also got to have your notice of privacy practices, and that notice of privacy practices has to contain certain elements and has to be in a certain format and things like that. So don't just rely on your general website privacy policy terms and conditions to satisfy HIPAA. In fact, your website terms and conditions may be contrary to your notice of privacy practices. It probably says something like, we generate cookies that we will use for, sell to third parties or whatever it might be. Well, that's contrary to HIPAA and contrary to what your notice of privacy practices would permit. So make sure that you take a look and make sure that those coordinate your notice of privacy practices and your general privacy policies and terms and conditions that may be associated with your website. All right, real quickly, let's go through a couple of these other things. The government is expanding their privacy concerns, right? Now you've not only got the OCR involved in this, but you've also got the FTC. The FTC is actually using Section 5 of the FTC to go after entities for data security breaches, not just healthcare entities, but healthcare entities are among others. Their theory is that under the FTC, the FTC Act, it prohibits unfair and deceptive trade practices, and the government takes the position that, look, if you're misleading your consumers concerning your security practices, so you're publishing these privacy policies, but you're not complying with those, or you're misusing information or causing harm to consumers, then that's a violation of the Federal Trade Commission Act, and we can go after you under Section 5, and you can look at some of the cases just over the last year where the government's gone after those entities. So you not only have to be concerned about HIPAA and the OCR, you've got to be concerned about the FTC. In addition, the government recently finalized their health breach notification rule, the FTC did. Now, this is different than HIPAA. In fact, the health breach notification rule doesn't apply to HIPAA covered entities. It applies to other entities vendors who collect personal health information. So they're not covered entities under HIPAA, but there are other entities who have health apps or the like who collect this health information. Under the health breach notification rule, the government says, the FTC rule, this rule says, hey, you other entities, if you're a vendor of protected health, a vendor of this personal health information, and you have a breach, then you've got an obligation to notify the individuals, and you've got to notify FTC. In certain circumstances, you have to notify local media. The government just started, as of a couple of years ago, started enforcing this, and there was a high-profile situation where GoodRx had to pay $1.5 million for a violation of the breach notification rule. The government, the FTC, has been actively warning people about potential violations of this rule, as well as FTC Section 5. In April, they issued their final update to the health breach notification rule, in which they confirmed that the breach notification rule would apply to tracking technology, mobile apps, those types of things. So even if you're not a covered entity under HIPAA, but instead you're a vendor and you are involved in these health apps, then you need to be aware of this rule. The SEC is now also requiring regulated entities. So if you're a publicly traded entity, you've got to report material cybersecurity incidents within 4 days, or material information about regarding cybersecurity management. You've got to report that to the SEC. The OIG is getting involved in it also. They emphasize that data privacy and HIPAA compliance should be part of your regular compliance program. States are also actively involved. More and more states are having their own consumer data privacy laws. Just remember that if a state's law is more restrictive than HIPAA, you got to comply with the more restrictive state law. Here's a summary of those states that, at least as of today, I think that have their consumer data privacy laws, but a lot more are active. Here's a summary from a source that identifies pending legislation dealing with privacy issues. So make sure you're aware of not only the federal rules, but also the state rules when it comes to this. Real quickly about cybersecurity, huge issue. This is a huge issue for all healthcare providers. Really, your biggest concern under is not HIPAA or the government enforcement, it's liability under cybersecurity. Just consider the Change healthcare attack and the impact that that's had throughout everything. I just saw, for example, that the OCR just issued a program guidance that said that Change is responsible for doing the breach notification, which for those of you who are affected by that, that's probably good news. But it's an example of the huge impact that cybersecurity breaches can have on you. They can adversely affect patient care and the like. I think that the current last estimate I saw is the average data breach for a healthcare entity is about $11 million. The government obviously is very concerned about cybersecurity in the healthcare sector. And in December, they actually issued their guide, their strategy for strengthening that, among other things. They are going to enforce cybersecurity requirements through the HIPAA security rule and the like. I would anticipate that we would get these new rules in 2024. So just watch out for that stuff. As I mentioned, the government, the OCR is getting on board, and for the first time, they've started going after entities for cybersecurity lapses, including one hospital system got hit for $1.25 million based on a hacking incident. The government has a whole wealth of cybersecurity guidance and helps out there. They've been very active in trying to help the healthcare industry. As part of their strategy, they decided that they would have a gateway, and they have now published that gateway so that you can go to this gateway and it will lead you to a bunch of resources on healthcare data. In January, the government issued their cybersecurity performance goals. These are voluntary, but they kind of give you a framework of goals you should have for cybersecurity guidance. In February, the NIST provided its cybersecurity framework, which is an updated framework that should help you work with your IT people to make sure that you've got a robust cybersecurity protections. It addresses those issues there. OCR has a bunch of reference resources on their websites. The government has ongoing resources that they will notify and provide alerts to healthcare providers who sign up for their listservs on things like different types of ransomware attacks and the like. If you haven't signed up for those, I think that you should send these resources, these links, these slides that I provided to you, to your health IT people, so that they can spend some time checking on the cybersecurity resources that the government has provided to you. All right, just real quickly on the information blocking rule. Remember, that's the rule that says you can't unnecessarily or unreasonably block the exchange of protected health information. It applies to actors, which are healthcare providers, but also developers of health IT and the like. The rules, the penalties for health IT have been in place for a while now, since last year. They can be hit up for penalties of $1 million. But in November, we just got the proposed rule for penalties for healthcare providers. Under the proposed rule, it's not a set monetary fine, but the healthcare providers can lose federal funding, different aspects of federal funding, if you don't comply with the information blocking rule. We don't have the final rule on that. You'll want to watch on that, but just make sure that you're aware of those potential penalties and you comply with the information blocking rule. For AI issues, I just wanted to point out that one of the major concerns of AI, which is obviously just expanding exponentially, is the data privacy concerns. The concern is that AI may actually get so much information that was not individually identifiable before becomes individually identifiable, or it collects information that is individually identifiable and breaches occur there. The government is actively working on coming up with a structure to regulate AI in the meantime. And by the way, some states do. For example, Utah has a law that requires if you're using AI and, for example, transcription or during your interviews, then you've got to give consent and things like that. So beware your state laws. But NIST actually came up with an AI risk management framework that might be helpful for you as you consider your regulatory and practical risks when it comes to AI issues. All right, I know I went through a bunch of that stuff fast, but I wanted to give you a heads up of those issues that are out there. Those slides should provide additional information to you as a resource. If you didn't get those, just shoot me an email. Also, we have a bunch of other resources available on our website for free, including the more detailed webinar that I did concerning Part 2 issues. That is it. Thanks for your patience. Good luck out there. It's a dangerous time out there in the data privacy world, especially with those cybersecurity risks. So make sure that you pay the attention that it deserves to make sure that you stay on the right side of the privacy issues. If you have any questions, feel free to shoot me an email and I'll try to respond offline. Thanks much, and I hope you have a good day.